afternoon, everyone in Europe. Good morning to those on the East Coast of the United States, and I'm not sure what time it is in Asia. I'm Charlie Reese, and hosting this panel. It's been a very interesting conference thus far, and we hope in this session to delve down into one of the, if you will, most vexing questions surrounding investor-state mediation, and for that matter, arbitration, which is the implications for the very important global challenge of enhancing sustainable development, particularly climate, but other kinds of environmental issues as well. Unfortunately, the interface or interaction between investor-state dispute problems and sustainable development has gotten a little bit of a bad rap, particularly in the civil society, environmental communities, and also with respect to consumer protection. That has arisen, I think, completely unintentionally because of the application of investor-state provisions to a couple of high-profile disputes, particularly between the United States and Canadian companies. But the suspicion of what the impact of dispute mediation and settlement, the impact of that on states' capacity to regulate and to particularly adopt new environmental provisions was one reason I think most Europeans would agree that the Transatlantic Trade and Investment Partnership got stymied politically in Europe, and also has been true in the American environmental community. The EU-Canada agreement, the CETA, was held up towards the end for the invention of, the invention of an investor court system, investment court system, which was designed to deal with that. So we're going to get into this question in the next session, and we have a terrific panel. We do not have Marat Aytanov from Kazakhstan, unfortunately not able to be with us today, but Ken Hyatt, Catherine Kasejian, and Anne Van Aken, are going to try and get into this. And I'm going to ask each of them to say a little bit about their perspectives before opening comments. But let me start with my own. I am sadly not a lawyer. I'm a retired American diplomat. I did have the opportunity to participate on 3 different bilateral investment treaty negotiating teams. In fact, was chaired that twice for the United States, and I was also a NAFTA negotiator. So from that perspective, I have had that experience. And then later in my diplomatic career, particularly as ambassador, I got involved in the efforts to find solutions to investment challenges. So with that introduction, Ken, can you say a few words about yourself? And then we'll go to Catherine and Anne.
Yeah, hi. Delighted to be here. Ken Hyatt. Currently splitting my time between Albright Stonebridge, which is a commercial diplomatic firm that works at the intersection of public, private, and the social sectors, resolving these helping deal with these kind of disputes. And a firm I started a number of years ago, CM Partners, which is a training facilitation firm. My background, I am happily not a lawyer, although I went to law school, Charles. But I worked for 20 or so years in the Harvard negotiation community. After law school, I became a consultant, but then joined Roger Fisher, that some of you might know, wrote a book called Getting to Yes, and I spent 20 or so years teaching negotiation, teaching conflict management, facilitating disputes around the world, and then joined the US government in 2010, would become the Undersecretary for International Trade. And I went from a teacher and a facilitator to more a doer, sometimes in the trade negotiation area, but did a lot of prevention and or resolution of investment problems around the world for American companies. So delighted to be here and delighted also to hear about such great progress in this area.
Thank you very much. Catherine.
Hello, everybody. Since we don't see who is on the screen apart from the speakers, it's always fairly difficult to know who is really listening or not. And this is a professor speaking. You know, you want to know who is listening, who is understanding, and who has eyes that show that, in fact, you are speaking really beyond the understanding of your public. So I am a professor. I am now emerita from the University of Paris 2, Panthéon-Assas in Paris. I have taught around the world, and I am personally bicultural, so that gives me a little bit of a head start for being an intercultural mediator. I'm also an arbitrator. I've started very early in arbitration at a time when it was possible to be an arbitrator at 30 years old. And since then, I've been a practicing attorney. I've been consulting. I always joke by saying that I did all the professions in the law, but huissier, process server, and notaire. So all the rest I've done.
Anne.
Yeah, thank you. I'm Anne van Aken. I'm also a professor, an Alexander von Humboldt professor at the University of Hamburg for international law, European law, and legal theory and law and economics. And I mention this because I'm, from my background, a lawyer, and I'm always saying in my last life I was an economist, but it really influences what I'm doing. And so for a long time, actually, I've done international investment law starting in the 2000s, in the beginning of the 2000s. And now I'm mainly working on psychology in international law, so a psychological approach to international law. Some of you in the audience, and if Meg is still here, she knows that was one of the first shots, was the experiments we did with arbitrators, international arbitrators at the ICA conference in Miami some time ago, trying to get into their mind and to see how rational they would adjudicate cases. That was the work together with Susan Frank. Early on, actually, some times ago, but in German, which is always a mistake, I published an article on debiasing through procedures, and mediation was my favorite example on how to debias people through procedures. So you will understand why I'm talking about this in a second. And more recently, I've turned back to mediation with Catherine. I've mentioned that quickly before when we were working together on the paper for the academic forum for the Untouchable Working Group 3 on mediation. And I guess I stop here.
Okay, thank you very much to all of you, and it looks like it'll be a fantastic discussion. So I'd like to ask Ken to start us off by talking about a little bit about sustainability policies of states and the interface with foreign direct investors in making those happen, and how the topic for our conference today and tomorrow interfaces with that. And start us off. And I can't wait for debiasing through procedures. I have to hold on for that.
Thank you, Charles. And again, thanks to all for the opportunity to be here. So again, for just a couple of minutes, let me put back my government official hat and sort of speak as a former official about sustainability policy, which is again the sort of the broader end toward which many governments are now thinking. The attention on poverty reduction, climate, inclusive economies, essentially the sustainability goals laid out by 2030 are a dominant policy conversation going on globally. COVID is just intensifying that conversation. It's fully my expectation that a new Biden administration, if you even look at some of the first appointments of this new Biden administration, whether it's Kerry in the climate role. The head of the NEC, the National Economic Council, is a person who has a great sustainability background. There will be continued attention to this issue. And from the state's perspective, one, those policy interests. Secondly, an ability to maintain flexibility in crafting regulations. If you are, and I don't know how many people are tracking the sort of the state of the regulatory environment in the climate area, there is tremendous variability as to how advanced these regulations are. In the most advanced nations, there continues to be an evolution forward in terms of how you deal with climate. So we sort of sit in a governments wanting to have the flexibility, and I believe a fundamental need for continued movement in the regulatory frameworks. I have worked in countries around the world where half of my conversations were, what is the regulatory framework for energy in this country? And so you're going to see continued evolution there. I think it's also fair from a policy perspective to say, and we've talked about capacity building with respect to mediation. I think there's a different capacity challenge, which is the capacity to deal with climate, and just the expert knowledge that exists in various governments around the world around how to think about solar, how to think about how you embed solar into the grid, how to think about resilient communities. So there is a capacity need with respect to dealing with climate that I think sits across. Obviously, the states recognize the need to draw inbound foreign direct investment because of the magnitude of the investment challenge here. There's I think there, without even going through the numbers, extraordinary investments needed to build climate resiliency. As all of that is happening, and Charles, you'll sort of appreciate this from your ambassador role as well, there are many, many countries that are also focused very much on improving the rule of law in their countries, right? Whether it is transparency, whether it is anti-corruption, whether it is what I would frame as good regulatory practice, just the way in which regulations are developed, and the intersection of evolving regulations, evolving practices by which regulations are developed, and climate, again, will continue to create pressure in this area. Switching to the investor for a second, and I think everyone, of course, knows the investors care about a risk-adjusted rate of return. They care about predictability. They care about future opportunities in a country. They care about their reputation. But I think, as was also mentioned, more and more companies, and there's more and more attention to ESG, more and more companies are integrating into their business planning and their business strategy how to manage the environment, how they are perceived. Rating agencies are beginning to assess climate and climate risk as part, and how sustainable a company is as part of the rating of those the companies. There's a task force on climate-related financial disclosures, TCFD. Increasingly, companies will need to disclose risk. I expect, again, in my understanding, this is moving in London now. It will likely move in the United States as well. I can imagine it moving in the United States. So continued attention to sustainability from the corporate side, from the private sector side. So sort of wrap all this together, and then just a couple of words on conflict. In the work that we're doing now in the sustainability area with clients, the companies are finding governments incredibly open and incredibly interested in collaborating on how to sustainably develop, right? The companies are finding it, the governments are reaching the companies. And what you see is both companies and governments recognizing that they cannot handle alone the sustainability challenges. And so it is setting up a collaborative environment in terms of how to deal with these issues, right? How to deal with these issues. You know, if you look at what will likely be extraordinary amounts of additional investment. If you look at the total base of investment now, I read something which said there's $1 trillion of foreign direct investment, of which only 30% is sort of sustainable from an environmental perspective. So there will be both extraordinary challenges going forward, lots of investment, shifting regulatory environments. There is a base of investment here where regulations will change, and it just sort of sets up both more issues and, though, I think a recognition about the importance of collaborating here. So then just connecting it then directly to our topic, at least for a moment, and then I'll try to be shorter, and then we can sort of answer questions. So this sort of topic of non-contentious approaches, of which mediation is one, feels consistent with this more collaborative approach as people try to deal with climate, try to deal with the sustainability goals, sort of point number one. Everyone here knows you promote better solutions if you do find these non-contentious ways, more interest-based. They tend to protect the relationship, et cetera, less costly, et cetera, et cetera, et cetera. A couple of additional points. If you, and I'm just trying to be additive to what's been said all the way here. If you look at the arc of a legal dispute, and let's say at the end there's a legal action, and before the legal action, there's a dispute. In my experience, before the dispute, there's a problem. And before the problem, there's a concern, right? And so again, Charles, if your experience, companies came to me in the US government and said, I'm worried about a regulation, right? The regulation hasn't yet occurred. So there's a concern. Or there was a regulation or an executive action, and the company said, I have now a problem I'm worried about. And this is, again, pre-dispute. Interventions at the concern stage and at the problem stage were always much easier to resolve, right? Much more easier to resolve. I've heard in the discussion so far, the legal framework to resolve disputes. I worked at the Department of Commerce, and if I was asked to deal with a commercial problem, I had the mandate to resolve the problem. If someone called it a negotiation, I lost the mandate to deal with the issue, and it would move from the Commerce Department to the US Trade Representative if it was called a negotiation. If it became a dispute that was being negotiated, it then activated an interagency process and all kinds of rules, regulations, procedures. So one question I do have, and that I would still say the group should think about, is in addition to legal frameworks for mediation, training, capacity building, et cetera, is again, how does one continue to find ways to intervene at, you might call it the informal stage, the concern stage, the problem stage, where it is much easier to make the intervention. On success stories, one place I would argue the group should look for success stories are in what I would call informal facilitated conversations, because there are a limitless number of success stories where an official, a US official or foreign official or British official, EU official, et cetera, facilitated an investor-state dispute where one of their investors raised an issue, there was a country that had a problem, and there was an intervention which was successful. Now, that might not be a formal mediation, but there's a lot of, and I don't know if anyone's looked for data there. And then the last thing I would say in this first pass through, and I was delighted to hear on the capacity building side, process design, I was delighted to hear about the curriculum. The questions I would have would be a couple. One is, it has been my experience over maybe 25 years teaching negotiation, facilitating disputes, et cetera, that although it appears easy, I don't find people are terribly good at really getting at the underlying interests of the parties and really framing, being able to leave the dispute and asking and understanding interest around the disputes to really taking the conversation to the fundamental underlying interests, the development interests, et cetera, et cetera. And that'd be one thing I'd be interested if it's in the curriculum. And then I guess, Anne, you're going to talk about this, is the emotional component of state to state, the emotional component of investor state, the identity issues. There is a lot that happens emotionally that blocks or interferes with the cognitive thinking around who has the merits on a particular case. And mediating in this area requires an ability to have a connect to the emotional component of the conflict in addition to simply the technical, legal, et cetera, because very, very often, at least in my experience, it's the emotional stuff that actually is in fact blocking agreement rather than the merits of whatever the case might be. And let me stop there.
Thank you very much. Yeah, there's a lot going on, and it's our focus is the sort of unfortunate emotional and sort of linkage between investor-state issues and sustainability. So, Catherine, as a practitioner, does this feel, does Ken's arc feel right? And how can we deal with this in the present circumstances?
Well, unfortunately, there is no controversy there. I fully agree. I could have, endorsed everything that Ken said. I do approach the issue from the objective, if you will. And the objective for me is prevention. So when we use mediation, facilitated negotiation, conciliation, whatever, but not arbitration, not court proceedings, we are aiming at preventing a dispute to get to what I call the crystallized situation, where it's becoming almost impossible to get rational attitude from.
There's no win-win solution. It's win-lose.
I don't use that expression. I know you Americans, you love it. First of all, in French, it's awful. Gagnant, gagnant. Oh my God.
No. All right. let me rephrase it. It's in
joint gains.
In game theory, there's a zero-sum solution, and right. There's also a cooperative solution, and it's the cooperative solution we want to get.
Great. I wrote something about collaborative arbitrator or collaborative mediator. I think it's ingrained in what we are looking for and what we are discussing on this panel. So if you take the prevention objective and you take that as the premise of the reasoning, then I have two tools that I would like to explain a little bit more. But again, it won't go as a controversial presentation to what Ken's presented earlier. The two tools are what we call as theoreticians, but it has very practical consequences. It's the rule of law. And I will explain in a minute what I mean. And second is dialogue. So cooperation, collaboration, etc. The dialogue is there. So what do I mean by the rule of law? When you are in the shoes of the state, and basically our panel is dealing with that. I mean, we have been asked by the organizers to really look at the state's position and the state's interest there. The state in investor-state disputes is really having a hard time because it has to deal with two adverse type of interest, which is the investor on one side, civil society on the other, and particularly when we are speaking about sustainable investment. And the state may have its own interests in the middle, plus a collective general interest to take into consideration. So the state is really the one who has the hardest job in the field, to get all these interests taken into consideration and dealt with. Now, I think the rule of law is helping the state, because when you speak of mediation or alternative dispute resolution mechanisms, and something has been said in the earlier panel, and Meg also mentioned that in her opening remarks. I think if you have a real democratic process in the state, then you will have the tools to make sure that the proper legitimacy of the negotiators are given to them, so that there is accountability within the process, and civil society will not be forgotten in the way that the accountability mechanism will come on. And therefore, it is very important that the people who are at the negotiating table, who are getting into the mediation and representing the state, and it's true also for a company. It's different kind of governance and different kind of democracy, but it's exactly the same kind of tools. Then the person who is represented, person or persons representing the state, has that credibility that has been built as something prior to entering into the process, and then making the accountability much, much easier. It doesn't mean that you still do not have to work on it as the mediation process is taking place, but still, if you do it at a very early stage, it's much better. Taking change in legislation as being one of the core issues in investment law, if the change in legislation is actually prepared, if you announce in advance, and I'm coming to the dialogue between the state and the investors, if you have a continuous dialogue with the investor, you as being the state, and announce that you need to proceed with new legislation, and you get an impact assessment, and you get exactly how the investors are going to be impacted by the new legislation, and you prepare that with everybody, then the chances you will get to a dispute are much less. And the chances you can actually mediate or facilitate through alternative means are much greater. So I'm coming to this dialogue, which is my third point in my presentation. The dialogue allows, and this is something we mediators are very keen on preparing and allowing between the parties, is what I call the common zone. Mediators are there to actually make sure the parties are building this common zone. And once the common zone is built, then you can get to solutions. Then you can get to the part where the parties can find common solutions to the difficulties they have encountered. And therefore, the dialogue is it's an ongoing process. What I'm advocating is that there is an interagency organization, institution within the state that will actually, from the very start of the investment, in fact, when the investment is conceived almost, it's like due diligence. It's an ongoing process. So you get this agency that will, from the state point of view, actually have that dialogue with the investor from day one and all along the performance of the investment. You don't leave the investor alone. The investor has this dialogue, and the dialogue is also with civil society. If you do that, the chances a dispute will crystallize are much less. So I'm going to stop here to allow discussion, but I think it's really where I come from and where I want to be, if you will.
Thank you very much, Catherine. Anne, thus far we've talked a lot about avoiding disputes and how do you avoid disputes and how do you set up the psychological process or the sort of dispute avoidance process. And you talked about debiasing through procedures, finding the contribution of procedures to that idea. Can you elaborate on that for us?
Yeah, thank you, Charles. I wanted to make it more specific and connected to sustainable development. So since the debiasing through procedures was 15 years ago, I thought about, and you made me think about, what's this sustainable development in here? And I think I want to just pick up on what Catherine has said. So you need to find the common zone. And I guess the common zone can be sustainable development, and this is what I would like to talk about. So I thought a little bit about a title, so to speak, for my short words, and here it is. So my question is, can sustainable development foster investor-state mediation success? And to give you the answer up front, I think it can, seen from a psychological perspective, and this is what I would like to talk about a little bit. So in order to show this, I will just quickly give you an idea of the behavioral approach to mediation, and then turn to some suggestions in the context of IS mediation, focusing on the role of sustainable development. And my main point is really that while deviations from rationality or biases in heuristics are usually seen as an impediment to successful mediation, in my view, there are good grounds to believe that sustainable development can be one factor conducive to mediation success. And what does sustainable development change in those biases and heuristics? Sustainable development is a common reference point now, and I think Charlie, you have talked about it, and Ken has also talked about it. It's a common reference point now for states as well as for business. It can and should be stressed as a common goal to be reached, and not adhering to sustainable development as operationalized in the SDGs with their respective sub-goals would likely lead to a loss for business as well, be it purely reputational or additionally by losing investors or consumers. So I think this is the point to start off. So what's this behavioral approach to mediation? And I'm talking more about the cognitive, less the emotional side, even though it does play a role. I think mediation, just as negotiation or arbitration, has for a long time assumed rational actors pursuing their interests completely rationally, using strategic behavior as modeled in game theory. Charles, you mentioned that before. Some disputes then fail to settle in mediation because there is no agreement that is preferable to adjudication for all the parties. And mediation can also fail as a consequence of strategic behavior of attorney-client conflicts of interests. But the question is whether this is a given. So the behavioral approach would look at research which looks at how people really behave, because the rational actor model is, of course, an assumption. It has been for a long time just an assumption. And if you look at the recent Nobel Prize winning economists, they usually work in behavioral economics, be it development economics, be it any other sorts of economics. So I think that approach has been really revolutionizing economics in large parts, but also international relation theory and also law and economics, where I traditionally come from. And of course, it has also been used in dispute settlement. The important point, I think, is that we cannot assume rational actors in a mediation process, since we do know that people are not entirely rational. So any stylized rational choice guide to mediation is likely to fail. That does not mean that there are not strategic interests involved. They will always be there, but there are many intervening factors. And I always am a bit skeptical when we talk about the interests as if they are given in stone. The perception of an interest is, of course, frameable. So I'm not saying that you can do anything, but I'm just saying it's not, there are gray zones on how we perceive our interests, how business perceives their interests, how states perceive their interests. So let me turn to some prominent biases and heuristics relevant for mediation. There are many more, and I don't want to talk about that, just to get to have an idea about what I'm talking about, okay? So there are three I would like to talk about if I have time. Otherwise, I confine it to two. One is overconfidence, and the other one is a fundamental attribution error. So the overconfidence bias basically says that on average, people are often overconfident in their predictions concerning the outcome of future events. This bias has been called among the most robust finding in research on social perceptions and cognitions of the last 2 decades. This also means that parties are usually overconfident in winning a case in court or in arbitration. And in that context, it was also found that people recalled significantly more facts favoring their own position than facts that supported the opposing position. A related and more troubling finding, called the illusion of control, is that people do not only think that they are better than average when skill or ability is relevant to outcomes, they sometimes believe that they have more control over outcomes than they do. And that impacts, of course, the choice between arbitration and mediation, because the problem caused by overconfidence in the mediation setting is pretty evident. So although plaintiffs dismiss some lawsuits after they are filed, most parties that come to mediation view arbitration as an alternative to settlement. And they will do so more the more overconfident they are or their lawyers are in winning the case. Now, the least invasive of many interventions designed to mitigate this problem of overconfidence is just to explain it to the parties. Well, you have this bias, you know, everybody has this bias. You probably have it as well, so reconsider, right? Then that might indeed work, and some studies show that does work. But there are more mechanisms for debiasing, such as exchanging views on the legal arguments to make clear that both sides may have good arguments. This is even more important in conjunction with sustainable development, as it should be stressed that non-sustainable development solutions, even if legal, may impact other variables in the utility function of business and states. Thus, adhering to the Sustainable Development Goals can be used as a further dimension where debiasing may be useful. That is, even if they believe that they may win a case in arbitration, not adhering to the SDG may be costly, since there are more risks associated with non-adherence to SDG or being seen not adhering to them. And that, of course, applies to business and states. And I think one interesting issue, which there are some studies on how arbitrators in ISDS have changed over the last, let's say, 2 to 3 years. But the data is hard to get. But it seems that there is, arbitrators have changed a little bit in their views on how they adjudicate cases where environmental issues are involved, and the sustainable development dimension may sway ever more arbitrators, thus also changing the calculus of who is going to win in arbitration. Let me turn to the attribution error. Attribution theory considers how people attribute causal meaning to behavior. And to what causal factors do we attribute negative events? We can either attribute events to the dispositional characteristics of the other part or to situational characteristics. The dispositional characteristics are associated with individual control or agency. That is, we usually assume people can control those characteristics. Situational characteristics, on the other hand, are external circumstances that are usually beyond the control of the actor. If events are attributed to dispositional factors, people tend to get angry because you could have done it differently, right? You state you could have done it differently. And they're less likely to concede or make any concessions. So how can then the attribution error be modified when sustainable development is at stake? Let's take an environmental regulation. The regulation will surely be attributed to the state and thus somehow to disposition, since there's a volition on the part of the state. A possible intervention is for the mediator to encourage the parties to explain to each other the reasons for their actions and to avoid focusing on blame or on legal liability. And that there is research which has shown that providing an explanation of mitigating circumstances for one's behavior can improve the perceptions in the eye of the other. Thus, explaining that the states may have taken the measure in order to foster certain sustainable development goals may mitigate the anger and thus foster potential mediation success. You can ask me to stop here, Charles, otherwise I take the third one.
Well, I thank you very much, and it's a fascinating conversation, but I am worried about time and leaving time for some of our audience to ask questions. Let me just bring back the question and ask each of you to maybe give me a minute's reflection on the political problem that we have, particularly in investment or capital exporting states, where the impression is that somehow dispute settlement, even by mediation, even attentive to these issues of sustainability is the future. Sustainability is what we're all seeking. We all have ESGs, etc. But there is undeniably in the civil society concerned about sustainability the view that while private investment is important and needs to be channeled in energy, carbon reducing ways and so forth, there is a feeling, a suspicion, a prejudice that the dispute settlement mechanisms, including mediation of this kind, always somehow come out with an outcome that is a little bit better for the investor than pure state regulation would be. How do we deal with that problem as a political matter? Because if we don't have everyone understanding that this is a good way to get to desired common outcomes, we will miss the opportunities that it provides. Let me start with you, Anne, and then Catherine, and then Ken. A quick round on that political question, and then I'll go to the questions from the audience, of which I have already a couple. Anne?
Yeah, thank you, Charles. I guess by now the capital exporting states are also capital importing, and I think, Europe has really had this experience. And I remember talking to German negotiators, investment treaty negotiators in 2010, saying, we will never have a case. We are a rule of law state. We will never be a case. I said, well, the US has cases. Yeah, but they are not the same sort of rule of law state. And we had the first one. And so they've learned their lesson concerning sustainable development, Italy and Spain, concerning renewable energy. There are lots of cases. So the Eastern European countries, certainly. So I think they have learned their lesson on that. So I would feel that by now, if I compare that like to 20 years ago, the formerly only capital exporting state, they have come much closer to where we should be going. And civil society in those countries might have played a part, but I think also having the experience of cases against them also has played a part. And I mean, some cases, like Vattenfall, the German Constitutional Court has also adjudicated, and they got their rights, right? So
yeah, but win or lose, you still get sensitized. Catherine.
Okay, I would take it from a different point of view. First of all, what you describe is a legitimate concern of civil society, of the citizens. We are all, when we think as citizens, we are concerned about how investors, companies are putting their own profits before doing a good job in terms of their activities and so on and so forth. And we have seen that again during the COVID situation, where companies have asked, at least in France, have asked to be relevé, I mean, not to apply a number of regulations on environmental protection. So here you go, it's there. So it's a legitimate concern. Now, how do you proceed to make sure that legitimate concern is met? And this is exactly what mediation is all about, and an alternative dispute resolution. And I put arbitration not in the alternative dispute resolution, because arbitration is a quasi-judicial system, and it has parties, and outside of the parties, it's very difficult to get people involved in an arbitration. In a mediation, and Meg alluded to that in her opening speech, in a mediation or in any alternative mechanism, you get more stakeholders than just the parties. And this is exactly what we need for sustainable development goals. We need to get everybody that may be affected by the investment, one way or the other, to be part of the conversation. And I'm speaking of a conversation on purpose, because this is exactly where false impressions will be dissipated, because when they are part of the conversation, they understand what's going on and they can actually be heard. What most people are asking is not that they have 100% of what they are asking, but they are heard, and that there is a legitimate effort to meet their concerns.
Yeah, I think that's very right. But what sometimes is argued is that these mechanisms aren't open. That is to say that there are, as a private mediation to try and find a solution, that it is contrary somehow to democracy. How would you answer that?
Well, mediation practice. We have developed means within the mediation practice to actually make sure all the stakeholders that need to be informed will be informed. Confidentiality has limits because, and let me give you an example which is not exactly on investment, but it's very similar. Labor disputes. You have a dispute within a company where you have like 10 employees that are concerned, but the outcome of that mediation is going to have an impact on the rest of the labor force. So yes, it is confidential. You don't speak specifically about what's going on within the mediation, but every single mediation meeting ends with, what are we going to do? And everybody within the room, not the employer, not the employees, it's a common endeavor. What is the press release, if you will, or what is the communication that we are going to say to the rest of the labor force, to the rest of the company, so that they are informed step by step of what's going on? What are the discussions? And, people speaking of confidentiality really don't know what we in the mediation processes have been developing as tools to make sure confidentiality is not there to close the information process. And this is very important in my view.
Excellent. Thank you very much. And finally, to you, Ken, we talk about all of these issues, and you're quite right that companies now are much more interested in sustainable development in every respect, and certainly reputationally. And as Catherine explains, information will help people have a better understanding of this. But it also is true that in order to make progress on the climate in particular, you deal with sort of a classic problem is you're a renewable energy investor and you want to build windmills. And there are two issues. One, people don't like to look at windmills, and so that's a sort of a public issue. And then there's an issue about what's your feed-in tariff to the state-owned monopoly. And so it looks like just a windmill investment starts with both a sort of a political problem and also an economic problem. And presumably over time, once the investment is made, over time, those problems don't go away. How is it that we can design a system that gives everyone, including the civil society interest groups involved, the confidence that their interests will be taken into account, but doesn't discourage the original investment, which meets the climate goals? You're on mute. Down at the lower left, I think, on my screen.
Yeah, sorry. You know, I mean, I don't know if I have anything more to add than, again, the sort of what is my level of commitment, in fact, to public consultation. And if you go back to whether the sort of the prevention conversation we were having, and even just this moment, just this conversation, this question you just posed around how do you deal with political forces who might be opposed to something, you know, they're just fundamentally different beliefs and the practice of actually consulting with people as part of your job as a government official, right? And I have met many government officials who allege an interest in hearing from constituents. And I have met many government officials who are genuine in their commitment to reach out to the civil society, to understand what's happening with the civil society, are honest with civil society, and to say, I'm here to listen, and there are other interests, and I need to balance different pieces, are good if a decision has been made around showing the respect to go and deliver a message to someone who maybe wanted a different outcome. So I don't know if it's a question. So for me, it all, you know, there is a little bit around, it starts with the degree to which you are in fact committed to robust consultation, listening, you know, making people feel heard, being creative in how you do these things. And I don't know that there is anything that I don't know there's any system answer other than that. Now, the only other thing I would say is, if you come back to what was being talked about around prevention, you know, there is, you know, good regulatory practice. There are sort of at least three core legs to good regulatory practice. One is public consultation. The second is regulatory impact analysis. And the third is a central organization in a government that helps manage multiple players, because the energy ministry might have a different view than the finance ministry, might have a different view than the commerce ministry, than the trade ministry. And, you know, good regulatory practice and good regulatory impact analysis is good for the environment, right? Because you do the hard work to assess what are the climate risks here, and robust public consultation. So in terms of designing it into the system, my answer would absolutely be, it's a question of this notion of GDR, right? Good regulatory practices, and the degree to which this is something that, you know, everyone is pushing everyone to get better at.
Yeah, I guess I would say that you're more likely to get disputes where you don't have good regulatory practices.
No
but
question.
You still have a dispute you got to deal with. Okay, enough from me. I'd like to call, if our folks can help us, on Professor Jarek Krivoj, who's Krivoj. Professor, go ahead.
Thank you very much. My question relates to specific dispute avoidance techniques which you saw in your practice. So we discussed already early neutral evaluation, but perhaps there are other very detailed, described in great detail techniques which others can use not to reach the dispute stage, but to avoid dispute. Thank you.
Who wants to take that on? Catherine or Anne, maybe?
Can start if you want. The first technique that I would propose to any state is to have this agency, institution, I don't know how you want to call it. Again, in French, we call it a guichet unique. So this body would be really charged with and sometimes in some of the states that I have in mind, I'm not going to name any, but this agency or institution is actually the one who is choosing among the different investors that are possible. So if they have a public offer or some kind of choice, then it's the same agency that once the investor has been chosen and allowed in, will follow the investment. So it's the same idea that I was mentioning earlier. So that's one of the tools. And the second tool, it's really the due diligence. I have both a background in public international law and private international law. So I'm going from one to the other. And I can tell you the due diligence that we are seeing now from the side of investors because of the UN guiding principles and the OECD principles, which are actually very helpful in terms of the SDGs, it's actually that due diligence, which is a constant, it's a different mindset, if you will, from the side of the investor and from the side of the state. So if you do that, some people speak of risk mapping, of that kind of mindset, then you would avoid dispute from arising. I'll stop here. There are many others. But,
Yeah. Anne, do you want to make any comment on that?
Yeah, no, very, very quickly. I think, it can be in a way one-sided. I think what we always leave out of the picture is the home state of the investor. And I'm thinking about it because if you think about the US or Canadian newer BITs or the model bit, they have those consultation procedures between the different ministries. So if you have, for example, a tax issue, why don't you consult with your own tax ministry and see what they say? And if they say, look, maybe you don't want to take up this case, they might want to you might want to consult. And the same issue can be in other issue areas of investment law. And then, of course, I think we always look at the Brazilian BITs being sort of BITs without teeth, but they do, of course, have some sort of institutions like ombudsman, which again could be an early on flagging of, now I say with Ken, a problem, not a conflict. Okay.
Right, there you go.
Yeah, I mean, I would echo what was said. So one is good regulatory practices, less problems. Second is somehow embedding within the government this ombudsman, aftercare, a person and or ministry, and in the best examples of that person or ministry is connected to the prime minister in some way. Sometimes those ombudsman roles are in like the Ministry of Trade, and they therefore do not have the interagency, quote unquote, juice, if you forgive my English, right? The interagency ability to move across the government. And the Brazilians have it, Select USA, and I helped lead the creation of Select USA in the United States. The first thing we did was we created an ombudsman, and then we created an interagency committee with senior politicals of all the ministries so that we had like instantaneously a way to go across. The other thing I would add would be, I heard mention of pre-mediation steps, which was like an informal assessment of the merits of the case. A different way of avoiding a problem is not to assess the merits, which is for me a legal piece of analysis. But what we have sometimes done is it's what we call facilitated joint brainstorming. So it is not an assessment of the merits of the case. It is very much a, let's talk through the problem we have, and is there a way for us to create our way out of this, separate from whatever the dispute is. So I would also put in the kit facilitated joint brainstorming in addition to those other process options.
Find the zone of possible agreement, right?
Yeah, well, but see, part of the issue for me is even that notion of the zone of possible agreement is to expand the zone, right? Some people are in this, they have, I don't know, people follow brain and neurophysiology. There's different parts of the brain that are creative and fight. There's all this work on the parasympathetic versus polyvagal theory, which literally has different parts of the brain are working. Some people, if they get into the dispute, they are more in a fight mode, right? And if I'm at a different part of my brain, I can, and Anne talked about, do people know their interests? I don't think people have any idea half the time what their interests are. So I think, brilliant mediation is enriching, adding, reprioritizing the interest sets around the table, right? It might be creating new ideas which do not exist at the table, which actually might be expanding. But that's like a different orientation, right? I'm creating, not arguing, not assessing who's the winner or the loser. It's a slightly different approach. Which again, some mediators are exceptional at. Some mediators, in my experience, are a little bit more, let me line up the parties. What's the merits of the case? Tell me what your concerns are. Let me do a little brainstorming. Let's get some people to evaluate the, and that's much more of a fight my way through the mediation, right? Versus create my way out of the problem, expand the playing field, add new parties, bring a fourth party in. By bringing the fourth party in, I might change the zone of agreement completely because there's a new player, but that's a much more creative, it's a creative approach to mediation, which again, different people have different levels of skill at.
Thank you.
Yeah, I remember when I was a trade negotiator, it's not exactly the same problem, but the problem that you face is that your principals, the people to whom you report, want a kind of a spreadsheet of wins and losses, and it becomes very difficult for the negotiator. And so what I always tried to do was to help the guy across the table, man or woman across the table, convince their principals that they're getting exactly what they want, that this outcome is going to be a terrific thing, and spend all my time thinking about what the other person needs to argue or present.
Right.
And if you can get in that mindset, then actually outcomes are easier to get. Everybody saves time. Next question is from Thomas John, who informs me in the chat that he is unable to be online. So I'm going to read his question. Perhaps a provocative comment about Catherine's point on the question of agency. And I preface this with making the point that this is truly an excellent idea, and an invitation to her and the panel to respond. Given the propensity of governments to overservice and be rather inefficient, potentially resulting in very bloated and costly agency, isn't there a good chance that the agency is far more expensive than the ISDs the state would face without such a body? Catherine and/or anyone else, I guess ISD is investor-state disputes that the state would face without such a body. The idea of government as being inherently inefficient and it's always, for those of us who served for many years in government, is always an appealing idea.
And from the side of the citizen that has never worked within a government, I can tell you, this is also the impression we have. I'm not sure how to deal with this remark. I mean, inefficiency is certainly, as I said earlier, absence of rule of law is one of those very basic difficulties we have to deal with in real life. So we'll have to find something to overcome that. I'm a bit short of ideas. It may be late in the day. I'm terribly sorry.
Fair enough. Fair enough. Anyone else?
Well, I mean, having been an official, let me use the argument and then take it in the different direction. If you agree with the basic notion that government is more hierarchical and more bureaucratic than the private sector, that for me is an argument about why you need the ombudsman. Because the agency who is playing that mediator facilitative role in the government, you might be worried they will be inefficient, but they are desperately needed, because you need someone to cut across the bureaucracy. You need someone to be able to talk to the energy ministry, the health ministry, the finance ministry, the White House. You need that facilitative role. That would be my argument.
Well, it gives me the idea that in diplomacy, we have now those ambassadors who are not ambassador to an organization or to a country, but are horizontal ambassadors for a topic. And sustainable development is one of them. Business and human rights is one of them. So that's why we have those people whose job is actually to make all the ministries, having a common discourse and position.
And may I just as a citizen jump in? I think it's far too sweeping to say government is always inefficient.
Yes.
It is sometimes, not. It depends on the country. I've lived in many countries. So just as a citizen, the connection you have with the bureaucracy can be very different. So I think what Ken and now Catherine have discussed is looking at somebody where you bundle the problem, who has the problem in the mind and then can reach out to other agencies. I think this is the way to go. And just by the way, I mean, if you look at big companies, they're far smaller than states, far smaller. So take a company of 300,000 employees. That's a big ship. They might be more efficient, but then the government is much bigger with many more dimensions and responsibilities. So you will always have friction in this. And I think on that issue specific on investment, the horizontal solution is probably the best.
Well,
I would completely agree with Anne. What I'm working on right now is how SDGs and sustainable development are impacting the governance of companies. And I think this is the next step. We need to see changes in governance of companies in order to have, a coherence between internal governance and external activities. Sorry, Charles.
No. That's a very, very useful point to make. We're kind of over time, and I'm concerned to deliver my panel on time. I would just one point that I thought might be useful is to think through this question that I posed at the outset. How can we reduce the suspicion of investor-state mediation and sustainability? And we've brought out a lot of ways to do that. Your last suggestion about ways to make companies and private sector actors more sustainably sensitive, and ways to make the mediation process more transparent, ways to assure people that what we're looking for are win-win solutions, even though we don't use that word, cooperative solution. One other thing, it seems to me, is that if you look at the history of investor-state dispute settlement, I'm old enough to remember the 80s when we had a BIT program in the US, and it may be hard for people to understand, but for the US government, the idea of BITs had a certain amount of, let's make this a legal process so that we don't have to sacrifice other aspects of our political foreign policy with Chile over Kennecott copper, and we can give it all to the lawyers and they'll come up with an outcome. And that was one of the advantages, believe it or not, of ISDS at the outset, was that it was thought that it would depoliticize investment disputes and actually save the government from foreign policy costs for these kinds of things. And we've kind of come full circle. But it seems to me that at this point, the countries that actually want investment in order to deal with sustainability concerns, recognizing the special sensitivity of sustainability for civil society and others, need to make the case. They need, in order to get that foreign direct investment, you need to basically assure the investors that they're not going to be scapegoats for other problems, and to set up a collaborative, transparent, mediation-driven process could be part of the solution. And so I think that all of our conversation today has brought out these kinds of issues, and the fact that it isn't just, as Anne says, a rational process. We need to take cognizance of what we've learned of the way that negotiations play out, the way that players put their positions forward, and that's part of what the mediation community can contribute to meeting our larger sustainability goals. So I am told that I am to wrap up and hand off to James for closing remarks. Thank you. Let me thank each and every one of you, our panelists, Catherine, Ann, and Ken, for a fantastic panel, and for letting a non-lawyer like me join you on this occasion.
And thank you, Charles, for your stewardship and preparation.
Thank you.
Thank you. Thank you, Charles.
I invite everyone to read the other Q's and A's. There are some very, very thoughtful questions in the Q&A chat sequence.
Thanks,
James.
Charles, and the panel. Maybe we can pick those up tomorrow or at some other point. I've been asked by Bickel to have some closing remarks, and I promise I'll keep them brief, bearing in mind it's getting late in Europe. It's probably very late in east of Europe, where if you're there, and even in the US. When thinking about the closing remarks, I was trying to think of what were the common themes from today's discussion. And for me, there's sort of two, which I think I'm going to highlight. One is, in all our discussions, I think going back to what are we doing this for? And we're doing it for the disputants, in this case, the investors and the states, to resolve their conflicts and their disputes. And the points that Ken and others have made about that doesn't just mean at the dispute end, but also at the problem end, also thinking about this much more broadly and holistically is really important. So I think bearing in mind what the purpose of dispute resolution in this context is really important. And I think the second point, which I think came out right from the beginning when Meg made her keynote remarks, was that we really were looking for an effective dispute resolution system, and that by looking at the different processes, working together as options, as tools, and it really reflects a wider conversation that I've seen more broadly about dispute resolution. I was recently on a panel at the Chartered Institute of Arbitrators conference, and we were talking about the stages that dispute resolution has gone through, where initially you had, I think, the forming stage, and we had mediation, we had arbitration, and Meg mentioned that initially in ISDS, conciliation was considered to be the process that would be used, and then it became arbitration. So we went through this forming stage, and then what happened, I think, is we went through a bit of a competition stage where arbitration and mediation sort of set up as opposites to each other or in competition to each other. And we see that in the commercial space. And my sense is this probably has happened in the IS dispute space as well. But my sense from what Meg has said, what my colleagues on my panel have said, and what Charles and his panel have said is we're really moving into a stage beyond that now, where given where society is more generally, the needs of the disputants to cooperate for, in this context, to increase foreign direct investment, to get outcomes which are broader than just arguing over the legal rights. The communities need to cooperate and work together to provide an effective dispute resolution system for the parties. And that may be arbitration in some contexts, but often it may be a mediation process. And I think that if we work together collaboratively, by we, I mean arbitration and mediation communities, we can come up with creative ways to present these options to the disputants and for them to choose what method they want to use to resolve the problems that they are facing, either early problems, as Ken said, or if they do emerge as disputes, either mediation or arbitration, what is appropriate. So I think it's actually quite an exciting moment in the current situation to look at these reforms. And I think almost the pandemic and the issues which are thrown out, that's been thrown out, also highlights the need to collaborate across society in order to provide effective resolution of disputes. So I hope that's a brief summary of what I saw as a common thread, and I look forward to tomorrow's panels. I'm picking that up. I'm sure we will. We'll hear from Mercedes Tarazon in terms of actual mediation that she did in Investor-State. We've got the issues of climate change, which you guys touched on in the last panel, and hearing more about that as that relates to Investor-State. So I look forward to more of that, and I hope everybody that have joined us today got some value out of the panel's discussions. Thank you. Good day, good evening, and good afternoon.